Supreme Court of Iowa, in deciding the Varnum case, acted not only courageously, but in the highest tradition of their constitutional responsibility. I concur in everything that Bob Albee said to you this evening about the duty of judges, particularly at the appellate level, under the Constitution. I would commend to your attention those of you that have an interest in history and would like to know what the founders actually said about the independence of the judiciary and the role of the judiciary. The paper entitled number 78 in the Federalist Papers, authored by Alexander Hamilton, he explains there the importance of judicial independence and the notion of insulating the judicial branch from the forces from time to time of majoritarian feeling in the community, such as manifested by the campaign that Bob Vander Plaats is currently undertaking. The court, in 69 pages in the Varnum decision, analyzed the issues, analyzed precedent, including precedent in Iowa, including a case that I wrote years ago when I was on the court having to do with the family as an institution in our society, cases from other jurisdictions, precedent from the United States Supreme Court, discussed the analytical framework for determining the constitutional issue. This is, at its root, a civil rights decision. The issue for the court was whether the statute that limited marriage to opposite-sex couples would withstand scrutiny under the Iowa Constitution's Equal Protection Clause. And that is exactly the analysis that our court undertook. It determined first, within precedent, what the level of scrutiny should be, because there is a framework in analytical discussions of constitutional issues which deals with the exactitude or the care that a court takes in determining whether or not a statute can pass constitutional muster. And there is a least or a lowest level of scrutiny called rational basis scrutiny. There is the highest level of scrutiny which is present in cases, for example, age or race discrimination, which is a level called strict scrutiny, and there is a middle level of scrutiny. In the Iowa court, after examining all of the precedent from all of the courts in the country that had relevant decisions, including Iowa, made a determination that the middle level of scrutiny would apply in this situation. And that required the court to examine the rationales which were argued, and it was competently argued on behalf of the county. It was the Polk County recorder who was the defendant in the case, and the arguments were made several bases to try to justify the distinction that was made in the statute. And the court examined each one of these bases for maintaining the statute carefully, and ended up determining that none of these bases were sufficient to establish a basis for the discrimination that the statute exacted. And this was the basis then on which the court made its decision. Now, one can disagree with one or more of the intermediate steps that the court took in reaching its decision. I don't know, if I was on the court at the time, whether I would agree or not with the decision. I would have done my own independent work and then determined ultimately whether to join the opinion or not. But I do say this: when the court makes the decision under the Iowa Constitution, it is Iowa law, and I respect it. And so I would defend it unless or until it is overruled. The appropriate way, if one is unhappy about a constitutional decision made by the court, is not to try to oust the judges who made the decision, but to try to change the Constitution or to try to persuade a subsequent court to overrule the decision that the court made. But the campaign here is one which is an effort to intimidate judges, not only in Iowa, but everywhere, not to carry out their constitutional responsibilities, but to defer to the mob, or to what is perceived to be a majority view, and not to make unpopular decisions. But we depend on our courts to make unpopular decisions. They protect us. Courts exist to protect individual rights. They do not exist necessarily to protect the interests of the majority from time to time. The people spoke to us in Iowa through our Constitution. The relevant Constitution is our 1857 Constitution. And it is not accurate to accuse these judges of having been activists. It is not accurate to say that they made a decision which is beyond the jurisdiction of courts. It was a decision that was made within their jurisdiction and within their responsibilities to decide constitutional questions when they're brought to them. It was a courageous decision, and I think we owe it the appropriate respect. Now, as to the system we have had since 1962 this modified Missouri plan. And I started practice really just a year or two before it was initiated, and have seen it operate over the years, not just yesterday, not just under Governor Vilsack, but under all of the governors that we have had since 1962. And I was a member of the State Judicial Nominating Commission from 1996 to 2001. When I went on the commission, I was an elected member from what is the 3rd Congressional District. And I can't tell you to this day what the political affiliation was of any of the other members of the State Judicial Nominating Commission, except one who I later learned was a registered Republican. And he told me that when he later became a candidate for a judicial position. But during the 6 years that I served on that commission, I never once saw from any of the commissioners any evidence of partisanship in the nomination of judges or a partisan influence being exercised. In fact, when I went on the commission, it was during Governor Branstad's tenure, and every one of the lay members of the commission had been appointed by Governor Branstad. I don't know the political affiliation of any of those folks. I knew one was a former clerk of court, but I don't see any evidence of partisanship in the way it operated or in the nominations that resulted. The 2 members of the court who presently are on the court, in whose nomination I participated, were Justice Cady. He was nominated from what might be characterized as a Branstad commission, and Justice Strike, who was nominated toward the end of the period that I was on the nominating commission. I just do not agree that we have a partisan selection system. The 2 members of the court now who were very active in politics were outstanding lawyers. One had been chair of the Supreme Court Judicial Qualifications Commission, that deals with the discipline of judges. The other had been a Solicitor General of Iowa. Both of them were just brilliant lawyers with a strong record of public service. And they were among 3 nominees each time, and they happened to be the 2 that were selected. Thank you.